afternoon, everyone. I think we're going to go ahead and get started. My name is Michelle Seeger, and I'm president of the Political Law Society here at GW Law. And I want to thank you so much for joining us tonight for our Voting Rights Act panel, Shelby County versus Holder, Oral Arguments, Part 2. During the recent oral arguments for Shelby County, the justices asked a few key questions that may actually determine the outcome of the case. Tonight, the panelists will discuss these important issues and their potential impact on the future of the Voting Rights Act. First, I would like to introduce our moderator, Professor Spencer Overton. He is a GW Professor of Law and Director of the Political Law Studies Initiative. So I'd like to welcome up Professor Overton.
Michelle, thank you so much. Appreciate it here.
So, as Michelle mentioned, my name is Spencer Overton. I'm a professor here, and I'm also the director of the Political Law Studies Initiative here at GW. And as she mentioned, we're going to cover issues from oral arguments. Some key questions were raised during oral argument. For example, Justice Kennedy asked whether Section 5 violates the Equal Footing Doctrine. He also asked whether litigation with a bail-in remedy might be an adequate substitute or replacement for preclearance. So it's very possible that the answers to these questions could determine the outcome of this case. And so we're fortunate to have some great experts here. Thanks so much to Michelle Seeger and also the Political Law Society and all its members for pulling together a great event. I want to also provide a disclaimer. We've got a great panel here. Two people who are generally supportive of upholding the act, and two people who are skeptical of the act and think that the court should strike it down. I have written in support of upholding Section 5. In this particular venue, however, I'm playing the role of the moderator. And so I really look to all of the panelists to hold me accountable, to keep me honest. Jerry, make sure I don't bend over backward to be too fair, and slight you, and Mike and Abby, keep me honest here, okay? So I want to start by introducing our panelists here, and let's start with the two people who support the petitioner, Shelby County, which is bringing the facial challenge to the coverage and preclearance provisions of the Voting Rights Act. Mike Carvin is a partner at Jones Day. He's argued several cases before the U.S. Supreme Court and state Supreme Courts, including the 2000 case of Bush v. Gore before the Florida Supreme Court in the election recount controversy. He's a 1982 graduate of GW Law School. Dr. Abigail Thernstrom is vice chair of the U.S. Commission on Civil Rights. She's also an adjunct scholar at the American Enterprise Institute, and she's author of several books on voting rights, including Voting Rights and Wrongs and Whose Votes Count. I want to move on to our two panelists who support the respondents, who are essentially defending the contested provisions of the Act. Jerry Hebert is the executive director and also the director of litigation at the Campaign Legal Center. From 1973 to 1994, he served in the Department of Justice, where he served in many supervisory capacities, including acting chief and deputy chief in the voting section of the Civil Rights Division. Darrell Lindseyenbaum is an associate counsel at the Lawyers Committee for Civil Rights Voting Rights Project, and she works there to implement the nation's largest nonpartisan voter protection program. She's also a 2011 graduate of GW Law School. So I want to start off with the first question here, which is, does the coverage formula violate an equal footing doctrine? And Shelby County, let me turn that over to you, Mike or Abby. Does the coverage formula violate an equal footing doctrine?
Sure it does, for two reasons. As you probably know, just a little background, the reason you can enact the Voting Rights Act, or Section 5 of the Voting Rights Act, is because the 14th and 15th Amendments at the end say you can enforce these amendments, which prohibit racial discrimination in voting and racial discrimination generally, through appropriate legislation. So the main reason it violates the Equal Footing Doctrine is because they used a completely outmoded formula looking from elections from 1964 through 1972 to figure out which states or counties were covered versus those which were not covered by the extraordinary preclearance requirements. It's as if the Congress in 1965, when they first enacted the Voting Rights Act, had looked at the Calvin Coolidge election to figure out which states had current problems that needed remediation through Section 5. The other reason it violates the Equal Footing Doctrine, or is simply not appropriate enforcement legislation, is because it didn't ask the key question through this so-called voluminous congressional record. No one ever asked, well, do we need Section 5 on top of Section 2? Section 2 of the Voting Rights Act is the principal component of the Voting Rights Act, which prohibits any voting system or procedure with a discriminatory result. You don't need to show that it was purposefully discriminatory. So this is obviously a broad prophylactic measure which can eliminate any conceivable problem that remains in the covered jurisdictions. So the relevant question is not in 2006, is there still discrimination that lingers in the covered jurisdictions? I'm sure the answer will be yes in 2006. I'm sure the answer will be yes in 2031. But the relevant question is there discrimination that Section 2 can't effectively remediate? And unlike the South in 1965, where they did have these recalcitrant jurisdictions that were evading court decrees, there's no argument that Section 2 doesn't remedy the problems. Indeed, the principal evidence that the proponents of the extension argue is that there was a lot of Section 2 suits in the covered jurisdictions. Well, if that's true, that proves my point that they're quite successful without Section 5.
Respondents? Equal Footing Doctrine.
Well, first of all, let's talk about the Equal Footing Doctrine. I looked at the Constitution this afternoon, and for the life of me could not find in the Constitution where the Equal Footing Doctrine comes from. Now, some may claim that it's in the 10th Amendment, but it's the only constitutional provision that really talks about equal footing of the states is Article 1, Section 9, Paragraph 6, which talks about how Congress can't favor one port over another. And that's it. The Fifth Amendment guarantees due process to all, which by interpretation includes equal protection, but only to persons, and states have been held by the court not to be persons entitled to the due process, so it couldn't fit there. And then secondly, they're not citizens, which the Supreme Court has also held in many diversity cases at states and state agencies. So, I don't think that the conservatives on the court should, including Mike, who's not on the court, but would like to be probably, but I don't think the conservatives really ought to be adding new rights into the Constitution. When will people stop trying to rewrite the Constitution to fit their particular arguments? Going to this issue about the outdated formula and things like that, look, in 2006, what Congress did was they didn't impose a reverse engineering formula, as some have said. Because that really sounds like a manipulation. But they didn't do that. What they did was they said, okay, what is the problem that we're trying to get at? They found that it was voter registration discrimination, and that, in fact, that affected the ability of minorities to actually vote and turn out. So they decided to draft the Voting Rights Act as a remedy for that problem in 1965. And they incorporated in it a bailout provision that allowed jurisdictions that shouldn't be covered to immediately opt out, and those that couldn't opt out were part of the reason that Congress did what it did. So, the formula is self-effectuating, and to talk about a formula as if it was set in stone in 1965 and hasn't changed, I think is inaccurate.
Daryl and Jerry, let me just follow up with you on this, which is, I understand say, hey, no equal footing doctrine, but Namundo, which was the case just a couple of years ago that decided a similar question, has language, right? Departure from the fundamental principle of equal sovereignty. Historic tradition that all states enjoy equal sovereignty. So, even if it's not in the Constitution, isn't the playing field essentially one in which, the court, at least, 8 justices who were in the majority there, recognize some principle?
Well, they didn't decide the case on that grounds. If I could just go one more time. They didn't decide the case on that grounds, obviously. They decided it on a constitutional avoidance question by reinterpreting the bailout provisions. But actually, selective application of legislation by the Congress to particular states is actually the hallmark of what the Supreme Court says Congress should be doing. The Supreme Court has invalidated laws back to the civil rights cases in 1876 when they applied the civil rights laws of 1875 to the nation. The Supreme Court struck it down saying, hey, you didn't go after the places where the real problem was. Even in the Violence Against Women Act, which got struck down within the last decade or so, the Supreme Court struck down the act because they said it didn't apply to just some states, it applied nationwide, and it was not therefore remedial in nature. And the Supreme Court, by the way, has repeatedly said the Voting Rights Act is remedial legislation. It doesn't create any new constitutional substantive rights. It's a remedy for the problem that Congress found, and jurisdictions can bail out if they want to.
Abby, Mike, earmarks, disaster relief, Yucca Mountain storage of radioactive waste. These are all areas where states are treated differently. Isn't this concept of an equal footing doctrine limited to congressional conditions on admission of states to the union here? Doesn't the federal government treat states differently all the time?
Sure. And again, the issue, just to make it clear, the constitutional provision of the issue is you can enforce the 14th and 15th Amendment. That doesn't mean you can amend the Constitution to get at things that the 14th and 15th Amendment get at. Section 5 clearly exceeds the Constitution because it prohibits things with a discriminatory effect, not just things that are purposefully discriminatory, and it makes you pre-clear changes. Come to Washington and ask Jerry Hebert, is this law okay, before there's a scintilla of evidence that there's anything wrong with it. So the question you're asking under the Equal Footing Doctrine is, have they identified those states that can't be fixed through Section 2? And since they didn't ask that question in 2006, and since they didn't update the formula, the answer is clearly no. Under your theory, they could have said every state east of the Mississippi River is covered and every state west is not. Well, Shelby County is east of the Mississippi River, so I guess that's okay. No, you need to have a reason that focuses on deficiencies in the existing civil rights laws. If they required every state in the country to pre-clear, to come to Jerry and say, is it okay if we hire another fireman or another police officer, you would have to ask yourself the question, not is there employment discrimination in the states, you'd ask yourself the question, well, why doesn't Title VII, which has an effects test which goes beyond the Constitution, not effective at remedying that employment discrimination? And that's the question the proponents keep evading. That's the question that Congress didn't ask itself in 2006, because everyone knew the answer was if you updated the formula, you would let a whole bunch of the covered jurisdictions go, and the only covered state would be Hawaii.
Okay. So continuing on coverage, Dara, the formula, the existing formula, is based on data from 1964, 68, 72 elections, right? In terms of turnout and tests in terms of the existing formula. Question here is, does Congress under the 10th Amendment or the 15th Amendment have the power to kind of reverse engineer? Jerry talked about reverse engineering. And does it have the power to determine which states it wants to cover and which states it thinks discrimination exists, and then kind of figure out a formula that roughly tracks those states and kind of back into it with this coverage formula that doesn't explicitly list the states that are the worst states?
Well, Congress did a number of different things when they came up with this formula, and they've continued this, and this is the formula that exists today. And yes, they were looking at testing devices and registration data, but the current formula they're operating under actually does take into a number of different things. It's not only what covered them in 65, 75, etc., but it's also the current trends and current issues that we're facing in these states. In all of these states that are covered, or the majority of states that are covered, voting discrimination is so deeply entrenched here that it was found to continue to be needed. So these 15,000 pages of documents, the 21 hearings that they had in this most recent authorization really did, I don't think it's fair to say reverse engineer. They were establishing that this formula not only works, but it's still necessary to continue.
Abby?
Well, sorry, I've got a froggy throat. Look, to say voting discrimination is deeply entrenched in the covered jurisdictions, which includes like 3 boroughs in New York City, but not the other 2, and so forth, scattered counties across the nation, is to say racism is still a significant problem in America in 2013. And when you're talking about voting rights cases, you are raising fundamental questions about the fabric of American society. What's going on with race? The question of racism runs through all discussions of minority voting rights. And my reaction to Professor Overton's 3 questions when I got them was, no. I don't answer those questions, and I'm going to tell a story. A friend of mine was a long time ago on.
They're not my questions. They're Justice Kennedy's questions. But go ahead.
That's all right. They're not the questions I want to answer. A friend of mine a long time ago, this is my little story, was on the Bill Buckley show. And, I don't know, he had 3 or 4 people, panelists on it, not just like we do here. And when he got to my friend, he asked a question in Latin. And she said afterwards to him, "What the hell were you doing?" And he said, "I was teaching you a very important lesson. Never listen to the question. Just say what you want to say." I've taken that lesson to heart, and I've followed it for years. Answer the questions you want to answer. And in my view, the questions that are interesting when you get to minority voting rights, Voting Rights Act, are huge normative questions. The extent of ongoing racism in this country is one of them, but there are lots of others. I mean, I look at the law, I look at cases. I used to teach, briefly taught Harvard undergraduates the Big Con Law course. I look at Supreme Court opinions as a forum in which to discuss basic American values, both political and cultural. And the questions around those values are what interests me. Like, what does a multi-ethnic, multiracial democracy look like in practice? When are racial and ethnic groups on equal electoral footing? How do we know when the goal of racial equality in the American polity has been achieved? Equality such that blacks are free to form political coalitions and choose candidates in the same manner as other citizens. I could give you a long list of normative questions that I think are implicit in these voting rights decisions. And maybe we can talk about them in the discussion. But those are the questions that interest me. I'm not a lawyer, I'm a political scientist. People for years said, because I write on the law, go to law school. And I said, no, lawyers ask the wrong questions, in my view. And so, with apologies to Professor Overton.
Like I said, it's not me here. Mike, reverse engineering. I mean, legal documents all the time, we refer to a class without specifically naming them. From a constitutional standpoint, why do we have to name states here? Why can't we just apply some proxy or some formula? And if Congress believes that those are the problematic states, put them in there. You know, the Constitution, I don't know that it refers to slaves, right? It explicitly avoids the language slave, right? So why can't Congress make the decision of, hey, we'll come up with a proxy and we'll put the states that we think are the worst actors under the proxy?
I think they can.
Okay.
That's my whole point. They didn't. They looked at who were the worst actors in 1965. They didn't look who were the worst actors in 2006 or 2031. No rational person can say that Manhattan, which is covered, is more racially discriminatory than Arkansas and Oklahoma, which are not. And therefore, you should have looked at, as the court put it in Amundo, since you're imposing current burdens, look at current needs for this legislation. By the way, this reverse engineering argument was propounded by the Justice Department as somehow a defense. They said, I don't know why they made the argument, in all honesty. They said, well, we could have named Alabama, Mississippi, Georgia, but we don't want to do that, so we created this fake formula so we could get them, and then we had to throw in a few others. I don't really much care if you do it honestly or dishonestly. I just want you to base it on some data that tells me that these states, uniquely among all others, are somehow immune to effective voting remediation under Section 2. And that's what they didn't do.
Abby, and then I'm going to come over to Jerry.
I mean, the fact is, in 1965, the formula was absolutely right, and they did reverse engineering. They knew which states had to be covered.
So hold on. So what I'm hearing from you all is that reverse engineering is not a problem. So to the extent that Justice Kennedy is concerned about reverse engineering, he shouldn't be concerned about that. He should be concerned
It wasn't
about...
a problem in 1965. That's my point.
Well,
It was
Justice-
a beautiful formula in 1965 to hit the states that needed to be hit.
But just to be clear, Justice Kennedy was asking the government why they think this reverse engineering is a get-out-of-jail-free card, which was what the argument the Solicitor General was making. He's like, are you in a better position because you gerrymandered a formula to get Alabama than you would have been if you just named Alabama? That, to Justice Kennedy, didn't make any sense, and it doesn't make any sense to me.
Jerry?
All right, so let's see if we can unravel a few things, and at the same time, if you haven't had con law yet, bear with me. I want to talk to you for a few minutes about enforcement authority of Congress under the Reconstruction Amendments. So first, it appears, and I think this is one thing perhaps the panel can agree on, that the decision in Shelby County may well turn on what are the legal standards that should be applied in deciding whether Section 5 of the Voting Rights Act, this preclearance provisions, have become unconstitutional with the passage of time. In other words, and Mike puts it in terms of the 2006 record, not justifying that. Abby says the 65 formula was okay and the Voting Rights Act was hunky-dory, but now it's bad. So I actually went back and read a couple of cases. I know that it's going to shock a lot of you law students that we old-timers actually go back and read the cases, but here are two cases. The first time the Supreme Court of the United States looked at the civil rights laws after the Reconstruction period in a case called Ex parte Virginia in 1880. It was a case where a judge in Virginia had thrown all the blacks off the jury pool. And he was removed from office, and the question was, he was looking for a habeas corpus, they would put him in jail. The Supreme Court said that appropriate legislation under the 13th, 14th, and 15th Amendment is whatever legislation is, quote, adapted to carry out the objects the amendments have in view, whatever tends to enforce submission to the prohibitions they contain, and to secure to all persons the enjoyment of perfect equality of civil rights and equal protection of the laws against state denial or invasion, close quote. Now that's pretty good language, right? So that's not, granted it's 1880, but let's take it a little bit in the modern day view. In 1924, the Supreme Court had a challenge to the 18th Amendment, under the 18th Amendment, to a law. This was the Prohibition Amendment, the 18th Amendment. It's the only amendment in the Constitution that has been repealed by a subsequent amendment. And it was designed, the Prohibition, to make a fundamental change in the attitudes of the American people. And the issues came to a head in a case called Everard Breweries versus Day, 1924. And that issue was a federal law that barred doctors, you're going to love this, from prescribing beer for medicinal purposes. Okay? And it was alleged that the act was beyond the authority delegated to Congress. The Supreme Court says, first, rejects the 10th Amendment arguments and says, it's clear that if the law passed by Congress is within, this is a quote, is within the authority delegated to Congress by the 18th Amendment, and I would substitute for the Voting Rights Act the 15th Amendment, its validity is not impaired by reason of any power reserved to the states. And if the act is within the power confided to Congress, the 10th Amendment, by its very terms, has no application, since it reserves to the states only the powers not delegated to the United States by the Constitution. And now here's the part, Spencer, that I'd like to especially see what Mike and others, Abigail and Dara would respond to. The court made clear that where the Constitution draws the line, in this case, Shelby County is about drawing the line between whether Congress should make the decisions about whether racial discrimination in voting has ended or the Supreme Court should. It says, where the Constitution draws the line between legislative and judicial authority, when the question is the degree of the problem and the choice of the remedy. Listen to this. It is likewise well settled that where the means adopted by Congress are not prohibited and are calculated to affect the object entrusted to it, this court may not inquire into the degree of their necessity, as this would be to pass the line which circumscribes the judicial department and to tread upon legislative ground. Now, I would argue that just as the argument ended towards the end in rebuttal, the lawyer for Shelby County made an incredible statement during the argument. He said to Justice Kagan, quote, when she asked, who has the authority to decide when discrimination is over, right? Who gets to make that determination? It was Justice Breyer who asked it. And then he says, well, the Congress can assemble a record and they can look at the issue and examine it, but it's up to the Supreme Court to decide, quote, whether the problem of racial discrimination indeed has been solved, close quote. And a startled Justice Kagan said, well, that's a big new power you are giving us, that we have the power to decide whether racial discrimination has been solved. I didn't think that fell within our bailiwick, close quote. And it doesn't.
Mike and Abby, what's your response?
I don't have any problem with deferring to Congress's methods to eliminate the discrimination prohibited by the Constitution. For the third time, the Constitution prohibits differential treatment on the basis of race. There's not any evidence in the record that these jurisdictions are engaging in differential treatment on the basis of race in a way that's materially different than the uncovered jurisdictions, and that can't be remedied by Section 2. What Jerry keeps forgetting is that we have one statute that goes beyond the prohibition against differential treatment called Section 2. It prohibits everything with a discriminatory result. On top of that, we add another effects test called Section 5, and we add this extraordinary affront to sovereignty that says, come up and talk to some GS-15s at the Civil Rights Division and beg them to pre-clear your voting changes. All of that needs to be justified, as they said in the seminal case of South Carolina v. Katzenbach, showing that case-by-case litigation doesn't solve the problem. And that's the only question the court was asking. That's the question that South Carolina v. Katzenbach, the Warren Court, said was the right question, and that's the question the Justice Department can't answer.
So, Mike, we've got Peyton McCreary here from the Justice Department, the author of the McCreary study, right, which said that covered states account for 25% of the population, right, but they account for over 80% of the successful Section 2 litigation, and suggesting that there's a difference between covered and uncovered states. What's your response to that?
That just shows you Section 2 works beautifully in the covered jurisdiction, so you don't need Section 5. Number 2, the McCreary study is, with all respect, not introduced to Congress in 2006, was a post hoc justification dreamt up by the Justice Department after they got sued, and everybody in this room knows why there's a disproportionate amount of Section 2 victories in the South. 2 reasons, and Jerry, I defy you to deny this. There was a bunch of at-large systems under Section 2 in the South. That's why they amended it in 1982, was to eliminate the at-large systems, and because, of course, they've got 25% of the population, but they're the only ones with substantial minority populations that you can create these majority-minority districts. And when Jerry was there in 1994, they went through the South like Sherman and required everybody to draw these majority-minority districts, and that's which led to all these Shaw violations. So am I supposed to fall off my chair and be surprised that there's more Section 2 victories in the South when they're the only ones that can create the majority black districts that the Justice Department insisted on and that Jingles required, or that eliminated the at-large systems? No. I don't think think it's like, I'm going to sit there and go, gee, Minnesota's got a whole lot of people. Why don't they have any Section 2 cases? Well, you're not going to mix Norwegians and Swedes into a Section 5 district or Section 2 district. That's why.
I got you there.
Okay.
There are a number of different things in there. I think I'm just going to try to tackle one small part of it. So Section 2, I know we have a question there. I feel like we can jump onto that now. Section 2 does a number of things that are great across the country, but it also doesn't do a lot of things. And Section 5 really rejects the need for this costly litigation that Section 2 requires. Require hundreds of thousands of dollars, sometimes millions, huge inquiries. It takes a very long period of time to get these done, and the court had asked, what's the rate of preliminary injunctions, and it's quite small. I think it's 25%.
No, it's a lot less than that. The Solicitor General estimated it at under 25%, he said. Turns out the number of PIs in Section 2 cases is far less than 10%.
And how many, just so you're not misleading the audience, how many, exactly, how many Section 2 cases are resolved prior to the new redistricting plan going into place, just like you did in Texas? The notion that
we didn't resolve the Texas case before.
You got a decision out of the Section 2 court in what, October of
But the
20...
Supreme Court reversed it. That's a big precedent, Mike.
And you want to know why they did? Tell them why. Because the Section 5 court, the one that's so quick to decide, it didn't decide until July 2012. So the Section 2 court couldn't enter its remedy because the Section 5 proceeding was going so slow. So it is absolutely mythical to suggest that you have to wait for elections to occur before you can get a Section 2 remedy. And you know, Jerry, you don't need a preliminary injunction. You could get a permanent injunction prior to the elections occurring.
I don't think I said that we need to do a Section 2 suit before it occurs. That's not part of the problem. One of the main problem is really this huge litigation that needs to go into effect for a voting change, when if you're not getting that preliminary injunction, the election passes you far by. But what Section 2 also doesn't do, and what has happened in the covered jurisdictions, is you find that this discrimination is so entrenched that when they have a Section 2 case, and let's say the plaintiffs win, then they're going to do everything they can to circumvent this. Now, hopefully this is dying down, but there are just a number of cases in the record that Congress examined. I mean, cases throughout Alabama where people were trying to circumvent Section 2 consent decrees across Texas. This is why Section 5 is just so needed in these covered counties. Section 2 is just not enough.
So, in part, your objection to Section 2, I suspect, is based on the fact that the plaintiffs have to carry the burden of proof in Section 2 cases, and the burden of proof is switched with Section 5. And my response to that is, oh dear, Section 2 is a normal case where the burden of proof is on the plaintiffs. I'm shedding crocodile tears here. And the whole point, discrimination is so entrenched. Well, how do you measure how entrenched it is? You got some data for me? I stare at data all the time. I'm a social scientist. It doesn't look so entrenched to me. In America in 2013? No. So, again, just going back to something I said earlier, a lot of the discussion over voting rights does boil down to your picture of American society and the degree to which we live in a racist country.
Well, the hard data is actually in the record, and Congress didn't need to look at numbers. There's hundreds of
I don't accept that record as impressive at all.
But when you look at the individual cases, these individual counties, individual jurisdictions that have all of these reports that went into that 15,000-page record, you do see the story coming through that makes it perfectly rational for Congress.
Anecdotes.
Abby and I testified in 2006. I'm telling you, it's a joke that they seriously asked. They didn't ask themselves two questions. Is Section 2 enough to solve this problem? You won't find a finding, you won't find a legislative report that asks the only relevant question, and they won't ask themselves, hey, what's happened since 1972? If people were trying to figure out what the situation in 2006, they would have asked those two fundamental questions. But Congress deliberately avoided that.
So, Mike, what about this argument that 86% of objections are interposed to problems that are on a local level, right? And the argument is that plaintiffs on a local level won't have the money, and it won't be kind of as high profile, and as a result, these lawsuits won't be brought. This really goes to the question of, is Section 2 an adequate substitute? Is the litigation a substitute for the preclearance process? Maybe litigation with a bail-in procedure.
Well, 2 points. I hope we've conceded now that statewide redistricting is not in any way, shape, or form needed for Section 5 because it's the most over-lawyered area in the world, and all of the statewide redistrictings are challenged in court before they go into effect.
We are not so state.
You're going to have to give me an example.
I didn't hear what you said, Jerry.
We do not state.
No.
No.
But it won't-
Texas Congressional is a good example.
Yes, Texas
Senate.
Congressional is an excellent example where you guys went in and brought a Section 2 lawsuit 9 months in advance of resolving the Section 5 lawsuit. It's an absolutely timely litigation device that looks at precisely the same evidence, with the same experts as the Section 5 court looked at.
We didn't get a Section 2 determination from the...
Because they had the Section 5 hanging over their head, Jerry. You know that. You had a Section 2 determination, and they had to wait for the Section 5 court to decide whether or not the act that they were about to strike down was ever going to go into effect under Section 5. But your question is about local jurisdiction.
Right.
I think that, there's probably a little less, but it's tough to find any kind of local jurisdiction that hasn't had, with any kind of appreciable minority population, that hasn't had all of this very effective Section 2 litigation. Jingles involved. You can go through it, that many of the leading cases involve counties. The other point I'd make is there's going to be about 200 lawyers in the Section 5 division that, as of June, will be completely unemployed, and they should just switch them to the Section 2 litigation, and then they could bring all of these cases. 3, if you win, as you know, in a Section 2 case, you get attorney's fees. So it's not as if and every Democratic-affiliated group, every Lawyers Committee group, every NAACP group is devoting a lot of resources to it. The only difference between Section 5 and Section 2 enforcement is whether or not you make your argument in front of a court where you have the burden of proving something, or whether jurisdiction has to make the argument to a bunch of partisan ideologues at the Justice Department.
How many lawyers in the preclearance section? How many?
You said 200, but it's, there's probably a handful.
Whatever, but you know,
5 to be exact. Oh, come on. That's a handful. There are only 5 lawyers in the Section 5 section of the voting section.
well,
What?
yeah.
Sorry,
Yeah,
but
Jerry,
that's the
let's-
number.
No, come on.
Okay,
I-
yeah.
That's not even...
I thought we would resolve this for the
Yeah,
court since the issue came up. I thought this was an easy
But
one
I
for us
don't, I don't
here.
even understand the assumption that black voters in these jurisdictions have no means of defending themselves except by bringing Section 2 suits or using the protections under Section 5. I mean, blacks are the Democrats' most loyal constituents. What politicians in these jurisdictions with a substantial minority or perhaps a majority of black voters dares to oppose Section 2 litigation, going to the Justice Department with a Section 5 complaint, whatever. I mean,
but aren't a
blacks
lot
are
of-
not helpless.
But-
Aren't a
let me
lot of
just-
local races nonpartisan?
There might be, but look, the relevant point is, this is how we enforce employment discrimination, which is much more behind the scenes and much more the employers got all kinds of discrimination. Voting is out there in public. Everybody knows where their lines are drawn. Everybody knows where the polling places are. This is how we enforce housing discrimination, where again, you can have a lot more subtle, secret discrimination going on in the voting than in the voting system. It's how we enforce, indeed, every voting rights law, for every fundamental right, from education to housing to jobs. Now, why is it that voting alone, which has the fewest changes per decade out of any of those other areas that I've just mentioned, and the most public changes, can't be effectively enforced? But I'm happy to look at some data that says it can't be enforced through Section 2. And again, you won't find a finding, you won't find any testimony in that voluminous record saying Section 2 is not up to the job.
So, Dara and Jerry, why is voting different in terms of litigation? I mean, Section 2 allows for attorney's fees and shifting the cost, so, isn't the cost not as much of an issue? And, we have seen cases where preliminary injunctions have been entered, Section 2 cases that have been resolved within, as little as 6 weeks. And, why can't we just use bail-in as a substitute, litigation and bail-in as a substitute for this coverage formula and preclearance?
I'm going to start by saying, first of all, virtually every person I've ever heard talk about how, Section 2 is an adequate remedy in place of Section 5 has never litigated a Section 2 case representing plaintiffs. All right? It is not a lay-down situation by any stretch of the imagination, and it often requires enormous resources to mount that kind of a challenge. A case against Charleston County, South Carolina, which took a long time to litigate, finally went up to the Court of Appeals in the Fourth Circuit, which affirmed it. It cost the county millions of dollars to defend the case, and the plaintiffs, private plaintiffs, you simply aren't going to find private plaintiffs with the resources who are going to litigate over time that kind of a case. You just can't do
Did the
it.
county not have insurance? Because obviously insurance covers a lot of these cases.
Well, all I know is that they got billed by their lawyer for over $1 million. That was in a public record. But my point is not how much, it costs to litigate. Your point also is that when in the Section 5 preclearance, you're getting lots of voting changes every day. 20-something thousand a year are coming into the Justice Department for approval. And they're looking at changes oftentimes at the last minute that are of a minor nature, that people aren't really public. They're moving a polling place at the last minute. Nobody really knows until it's actually done, or a precinct line gets changed, and sometimes for discriminatory reasons. You don't become aware of those things, and you can't just run into federal court and say, this is going to result in discrimination, because you have so many tripwires that the Supreme Court has set in place for you that can blow you up in a Section 2 case. And I've litigated hundreds of Section 2 cases, not dozens, hundreds. And I'm telling you that you cannot win those cases without having millions of dollars in the bank to bring them and hire experts and do racial bloc voting studies and all the rest. And this idea that you could bail people in, that you could win a Section 2 case and then say, okay, we're going to bail them in. The only way you can bail somebody in is if you prove a constitutional violation. So you have to prove intent. If you prevail in a Section 2 case, you don't automatically get to bring them in under Section 5. The court only can do it if it finds intentional discrimination. And courts don't like to find intent because it labels somebody a racist, maybe, or you have to make detailed findings. And in most cases, they don't reach the constitutional issue if they find a Section 2 violation, because it's constitutional avoidance. So this whole idea is ridiculous. I think Mike gets up in the morning and he looks in the mirror and says, how many outrageous things can I say today that aren't true?
All right, well, since you personalized it, assuming for the sake of argument everything he said is true, then that means, of course, since the burden's on the jurisdictions under Section 5, they're the ones who have to spend these millions of dollars and produce all of this racial bloc voting analysis to prove to less than impartial people like Jerry Hebert that the discrimination is not there. And yet every day I hear people like Jerry saying, Section 5's not that big a burden. Well, both can't be true. Either you have to devote enormous resources to these cases, which imposes a tremendous burden on the covered jurisdictions, or it's not that big a deal. Moving polling places at the last minute, how many objections have there been to polling places since 1995 in the division? 12? We're going to keep 14 states under this sovereign thing because we're worried about whether or not you can get a TRO if they move a polling place out? How much does that cost to litigate? $100? You need an expert to tell you that if you move a polling place out of a black neighborhood, it decreases access? Come on. Now, you can... I've litigated a whole bunch of Section 2 cases, and I have never, ever seen one under-lawyered. I've never seen one that they've passed it up because they can't find one of the millions of public interest groups or partisan affiliated or Justice Department people to come in and bring the case. And since, as hopefully the Justice Department will be needing something to do once Section 5 is struck down, they can redeploy the resources. Seems a little odd for the Obama administration to say, the only things we can't afford in this environment are Section 2 lawsuits and White House tours.
Well, in addition, look, Jerry, it seems to me when your evidence of entrenched discrimination boils down to places moving a polling place from one side of the street to another, well, it's over, Jerry. You've lost the argument on the importance of Section 5. I mean, that's absurd.
It was an illustration of how something can happen that's minor, that's undetected until the last minute.
Jerry,
And Section 5 covers those.
I see this argument all the time. Well, there are polling place changes. Okay, big evidence of the fact that this is still a racist country. It's ridiculous.
Section 5 blocked Texas's intentionally discriminatory Congressional and Senate maps from going into effect. But for Section 5, those plans would have gone into effect.
It's completely and utterly untrue.
Well, I litigated the case and you didn't.
No, and I'll tell you, but maybe unlike you, I read the case. And the Section 2 court denied this, found Section 2 problems with the redistricting in Texas. True or untrue?
False.
Oh, please.
False.
Well, what did they appeal in Perry v. Perez that you defended?
They appealed the interim remedy
Thank you.
imposed by
And
the
they're-
court, but not under Section 2. It was to remedy a one-person, one-vote violation and a not insubstantial violation of Section 5.
Now you're just deliberately misleading these people. The reason it was one person, one vote was because they had to redistrict, and they criticized them for not adding the extra Hispanic district, which of course is the final point here, which this doesn't have anything to do with black imposing barriers from blacks or Hispanics voting access. This has to do with creating these Hispanic and black majority districts, or in Jerry's case, defending this 34% district that combo black and Hispanic that elects a white Democrat. That's what this litigation is about, and that's why Justice Scalia was entirely correct when he said this is all about preserving the racial entitlements created by Section 5. In addition to extending Section 5 in 2006, they amended it to make it harder than it was in 1965 because apparently they thought the South was worse in 2006 than it was in 1965. They overturned a case called Georgia v. Ashcroft, which said, look, if you have good reasons to eliminate a black majority district and you have the support of people like they did in Georgia, John Lewis, civil rights pioneers, we're going to give you some discretion about eliminating these districts. Congress overturned that and said, we're overturning Georgia v. Ashcroft and prohibiting you from diminishing the ability to elect in terms that were previously reserved for cases like Plessy v. Ferguson, which demonstrated beyond all controversy that what this was about was preserving these existing districts.
Okay, so I do want to move on here. Before I move on, I want to acknowledge our Dean of Public Interest, Alan Morrison. Alan, thanks so much for joining us here. Yeah. Let me turn to you with this, which is, this was a question that came up during oral argument. Is Shelby County actually injured if it would be covered by alternative coverage formulas? And then, Abby, I'll come to you next on this, and hopefully you'll answer, or not, or we'll get an answer from over there.
I think Shelby County would think it was injured under any circumstance where they have to submit for preclearance. So I guess that's kind of one answer. But, Shelby County, it's really, and Alabama itself, even Judge Williams in the lower court's decision didn't dispute that Alabama could be properly covered under any formula here. In the case, Shelby really kind of avoided all the evidence that came out and was selectively pointing to individual jurisdictions outside of Alabama that it found shouldn't be covered, and using these different examples of different states and jurisdictions that really they found didn't have this kind of history of discrimination. But Alabama and Shelby County are really different here, and there's really no one who's disputing that Alabama has these issues that have continued and continued. You know, during the reauthorization period, 240 discriminatory voting laws were blocked by Section 5 and Section 2 in Alabama. That's a good number of the whole lot.
Abby?
Well, I mean, we can argue over what the evidence is of continuing discrimination, but the fact is that the remedies, I mean, one hopes that the remedies used in situations which are allegedly discriminatory, that the remedies are furthering political equality in the political sphere. And I would argue they're not. They're not. These racially gerrymandered, and it's why Scalia brought this question up, it's these racially gerrymandered districts to create safe seats for blacks and Hispanics. And by the way, blacks and Hispanics are not one cozy, happy group. Those are not, there are a lot of tensions between those two groups.
And when you say safe seats, you're talking about when Justice Scalia talked about the perpetuation of racial entitlement?
Yeah, the entitlement to safe seats, districts that create absolutely safe minority seats. Is the racial gerrymandering remedy to create those safe seats, in fact, furthering racial equality in the political sphere? And I would argue no.
What do you say to the response that all politicians are looking to create safe seats, and regularly all politicians do create safe seats?
I would say race is different. Race is special, given our history, disgusting history in this country, with respect to race, that one wants to be very careful.
Jerry and Dare, what's your take on this?
Just let me say one
Okay,
thing
go ahead.
on this, Spencer. The notion that you have that blacks and Latinos, but blacks are the main group we're talking about here, are entitled to inequality in the electoral process, special protection just for them, because they can't participate as other citizens do, and expect, to gain seats and so forth. That's a whole separate argument I don't buy.
So Dare and Jerry, quota entitlement, is this just Section 5 just another form of entitlement program, handout, quota, affirmative action here?
It is an affirmative action. The Voting Rights Act is an affirmative action statute.
Okay. Dare and Jerry?
You want to go first?
You can go first on that one.
Okay, so racial entitlements. First of all, the right to vote in this country was a white entitlement for a long time, until the Voting Rights Act finally gave minorities an opportunity to become registered. So if you want to talk about racial entitlements, let's look at history, and historians will tell you it was a racial entitlement, all right, but for white folks. So that's point number one.
Jerry, nobody disagrees with that.
Well, okay, but let's not use inflammatory terms like racial entitlement and Justice Scalia, frankly, it's beneath the dignity of a Supreme Court justice to be as bombastic and cynical as he is about 98-0 votes.
Those race-conscious
Shame on
districts
him.
are not the same as racist registrars
There's
in
nothing
the Jim
racially
Crow
entitled
South.
under Section 5 of the Voting Rights Act, where a statute says that a state has to submit a voting change and prove non-discrimination in that voting change. That's a racial entitlement, that you're entitled to have a voting change implemented that affects your right to vote in a way that's non-discriminatory? Since when was that we're all entitled to non-discrimination, so everybody gets a racial entitlement, I guess. But the fact, it does say that voting changes have to be shown to be non-discriminatory in purpose and effect.
So you can't diminish the ability to elect. Are you ever going to defend that part of the Voting Rights Act?
The voting rights, Section 5 says...
You can't
that-
diminish the ability to
elect a candidate of your choice. So,
Yes.
and I'm not going to
It's
sit here and
you
try to listen to people like you and Abigail say that it's okay for white people to say, I'm going to pack all these white folks into my district, but when it comes to a majority-minority district, providing a group that's been historically discriminated against from creating a district where they can finally elect somebody of their choice,
Because they're entitled to it. We're all agreeing about
That's
what the
Section
law does. Now we're asking whether or not that's good or bad. Criticizing the Supreme Court justice for accurately describing the law simply because you favor the entitlement is really not fair.
And the entitlement he was referring to are these safe seats that are created by racially gerrymandered
and they
districts.
apply outside Section 5 as well as, the jurisdictions of majority-minority all over the country, including many states that aren't covered. We all know that. The fact is, though, that, and one thing that the students haven't been told, is that if these states and these poor put upon historically discriminating states really feel burdened by Section 5, they can bail out. Not a single jurisdiction since 1982 that has attempted to bail out from the preclearance provisions and not have to submit these changes anymore has been denied the right to get a bailout. And since 2009, when the last time the Supreme Court had this issue in front of it in the famous Namudno case, more jurisdictions have now bailed out than in the entire history of the Voting Rights Act since 2009. So the big Supreme Court opened the bailout door. They should let people walk through if they don't like and they feel put upon by these so-called racial entitlements. It's a joke, if you ask me.
Why can't these states bail out? And the jurisdictions bail out? I mean, comply for 10 years, have a clean record?
I'm sure Jerry would agree. It's like 1% of the jurisdictions bailed out. None of the states from Texas through Florida can bail out, because if you've had any violation within your jurisdiction, and anywhere in the state of Georgia, for example, in the last 10 years, you can't. They've got a 10 black, or if they even just send monitors. Just because they'll send a monitor to watch an election that in the last 10 years, that deprives you of the ability to bail out. And then you've got a 10-year clawback provision if there's a legitimate complaint for the next 10 years. So, yeah, everybody who applies gets out, but it's about 1%, and that's because everybody can read the law and say, I don't have any chance of bailing out. But if it was so simple to identify those who are bad and those who are good, why didn't Congress do it in 2006? Why put the burden on these jurisdictions to initiate bailout litigation? Why not just apply the formula and say, okay, we used to cover Manhattan and Brooklyn and the Bronx, but things are pretty good there.
Townships in New Hampshire.
Why don't we let these townships in New Hampshire and California go? The fact that they didn't do these very simple things, New Hampshire, a couple of townships in New Hampshire, shows you that they weren't interested in figuring out where there was real problems in 2006.
But they were interested in 1965 in that exact question, because they allowed people to bail out then, and many jurisdictions did immediately, states that shouldn't have been covered. Congress knew that some states would get covered that shouldn't have been covered, and so they put this bailout provision in and said you can get out. New Hampshire could have bailed out in 1972 when it first got covered, but they chose not to. They chose not to. It wasn't that they asked to. So the Congress has built into the coverage formula the opportunity for bailout, which, as I said earlier, adapts over time and changes, so that to talk about a coverage formula frozen in time, I just think is not capturing the accurate picture.
Shelby County, is a facial challenge appropriate in this case?
Sure, because you're challenging the statute on its face. In other words, it doesn't matter what the particular situation is in Shelby County. I brought a challenge on behalf of Kinston, North Carolina, which the Justice Department reversed at the last minute to try and moot out the case, because there was no problems in Kinston, North Carolina, which is a majority black city. And it really shouldn't matter which county brings the suit. The question is whether the formula works. To go back to my prior example, if they said, well, the states east of the Mississippi are no good, you wouldn't say, well, gee, Shelby County's east of the Mississippi, so they can't strike down a formula. That's irrational on its face. And I don't even know how it would work. How would you figure out, if you abandon the congressional coverage formula, then what formula would you submit? Would you have every county that's covered, all the thousands of counties come through and litigate it year by year? Well, we think you're a little less discriminatory than Perry County, which got out, but not Jones County, that didn't get in. So no, you're asking yourself, was the statutory mechanism congruent and proportional on its face? And if not, you struck it down, just like they struck down the Religious Freedom Restoration Act on its face. They didn't ask, does it apply could you imagine a situation where they were really getting at religious bigotry?
Okay. Adair and Jerry, facial challenge, appropriate here.
No. Long-standing Supreme Court precedent says a party can't challenge the constitutionality of a statute on the grounds that it interferes with the rights of others. That's long-standing here in Raines, Lane, etc. In Shelby, and all of the evidence they're using, they're talking about other jurisdictions that, like New Hampshire or Alaska, that don't have this discrimination there. Shelby avoids itself and is really trying to assert the rights of others here. If those other states don't want to be covered, they can bail out or do themselves like the Mudd case.
Okay. All right, so before we go to closing thoughts here, any questions out here? Any questions generally? Okay, all right. So, yep. Oh, Mr. Leonard, Lloyd Leonard from the League of Women Voters. How are you doing? We need to get you a mic, don't we?
I need to hear Mr. Hebert and Mr. Carver respond to the question about whether Shelby County's dirty hands somehow make this a question that they can ask the Supreme Court to pass on.
I'm sorry, it makes this, what? Say the question again?
I think the question was, if I could repeat it with a mic, was that does the fact that Shelby County perhaps has unclean hands, could that affect the decision of the Supreme Court and what it ultimately decides in this case? Lloyd?
Yes.
Do you want to go first over there, or do you want me to go first? Go ahead. So Shelby County is one of the only counties that you can identify immediately in Alabama that is ineligible to bail out, right? Because a city within their jurisdiction within the last 10 years engaged in intentionally discriminatory redistricting, which is a disqualifier under the bailout law. Of course, Mike says that none of the states can really bail out from Texas to Florida, but the fact is that many counties and cities within those states obviously should seek bailout and haven't, but we leave that question for another day. The fact is that what I think, and really it's difficult to predict what the Supreme Court's going to do, but the fact is that Shelby County, Alabama, being the only county that is not eligible to bail out because they have recent evidence of discrimination, ought to affect their ability to get a facial challenge to a law. Facial challenges are disfavored in the Supreme Court, and you essentially have to show that the application of that statute in all circumstances is unconstitutional. And that's a pretty heavy mountain to climb, which I don't think they can. I believe, as I said earlier, that the way that the court ultimately is going to have to decide the case is whether or not they view what Congress did in the Voting Rights Act in 2006 and all the other prior extensions was remedial in nature, or are they going to try to make up something that Congress created a new constitutional entitlement that is not recognized in the Constitution. And I think it's clearly they've held previously that it was the former, and they should hold that again.
Mm-hmm.
Well, since such a rare occasion to agree with Jerry, I want to emphasize that I'm about to agree with him. That's the question, right? Did Congress in 2006 do something that was remedial? The answer to that question doesn't turn on whether Shelby County is a racial nirvana or not. Surely you wouldn't strike down the statute if some clean county from Alaska challenged it, and then you'd have a different result because you've got a less clean county from Alabama. That doesn't make any sense. In either case, the question is whether or not Congress adopted a formula. To go back to what I think I said a couple of minutes ago, if they used a formula that everyone agrees is crazy, states that begin with the letter A, it wouldn't matter that Alabama is covered and you'd let them go, but you wouldn't let Alaska go, because what they've done is not try and enforce the Reconstruction Amendments. They've tried to do something very different without any justification that this extraordinary procedure that they've imposed on states beginning with the letter A is justified. I also can't imagine how you could have a county-by-county assessment of Section 5's constitutionality. Are we really going to have all 3,000 counties litigate from now till 2031 whether they're better or worse than the other counties? And how in the world are you going to apply a formula since Congress didn't apply the formula? And if you're asking whether they would be covered under an appropriate formula, the question again would be, are they in such a state of disrepair that Section 2 wouldn't effectively eliminate whatever discrimination goes on? And if you apply that question, then Shelby County and everybody else gets out.
One sentence to add. When they passed the act in 2006, Congress said, we're going to re-examine Section 5 in 15 years. They extended it for 25, but they said in 15 years, we're going to take another look at this. So going to Lloyd's question, I think there's also a possibility that the Supreme Court may say, look, Congress is going to re-examine the statute in 2021, and we believe there are serious constitutional concerns with the statute. Congress needs to fix it when it comes up in 2021, and if not, this court, is poised to, re-examine the constitutionality. I think that's a possibility.
Although it's the last thing Congress wants is to have on its lap, thrown on its lap, a demand that it once again look at the Voting Rights Act and the whole question of electoral discrimination in this country. I mean, this is a politically very difficult issue for most members of Congress.
Okay, we're going to do one quick question here, and then we're going to do closing statements.
Hi. This is wrong.
Okay, I think it probably is.
Okay. My question is, at oral arguments, one of the questions that came up between the parties is what the fundamental question is regarding Section 5. Is regarding the coverage formula being based on testing devices and voter registration. Is the problem that Congress was trying to address in 1965 and 2006 voter registration and testing devices, or was it racial discrimination in voting generally? And related to that question, do the so-called second-generation problems that exist today, well, first off, are they really second-generation problems? And second off, do they justify Section 5's reauthorization in 2006?
Okay.
Great question. You must be channeling Justice Breyer, because he asked almost precisely your first question, which was that if he said to the lawyer for Shelby County, well, look, if the problem that Congress was trying to remedy in 1965 was voter registration, equalization, blacks were unregistered compared to whites, and voter turnout, and based a formula to correct those things, then you have a stronger case. But if Congress was acting in 1965 to remedy voting discrimination, to find out what the problem was and to address it, and then created a formula to target where he thought the problem was, then I think you lose. So I think that's precisely the question. On the second part, the second generation questions, again, what happened was once blacks finally got registered and were able to vote, then we saw a whole series of what you properly termed second generation issues, which are changes that took place over time that diluted minority voting strength, or that maybe pre-existed the Voting Rights Act. And so now blacks who finally had the right to vote would go in an at-large election system where they constitute 30 or 40% of the population. Whites would never vote for the candidates of choice of blacks or Latinos, and the minority candidates would lose, and the jurisdiction governing body would be all white. And what Congress found when it examined it was that it did look at, contrary to what Mr. Carvin said, it did look at whether or not Section 5 was still needed to address those kinds of issues, and it found that it was.
So the issue in 1965 was access by minority voters to the ballot. And that was what the formula was designed to...
No, it was discrimination in voting, I said.
So the issue in 1965 was access to the ballot by minority voters, which is why you don't ask, for example, whether you ask, well, are they voting in certain amount of numbers? Are they turning out? Or are these testing devices excluding them from the ballot? So the formula and the problem was obviously excluding blacks from the ballot. Once they, as Jerry said, I think 45 seconds ago, got registration equivalent to non-minorities, then the question becomes the so-called vote dilution, which in essence is the failure to create majority-minority districts. It's an entirely different issue involving an entirely different set of public policy choices where reasonable people can quite sincerely disagree about whether, as Abby pointed out, creation of these majority-minority districts is in the long-run interests of minorities in terms of exercising effective political power, or whether distributing their influence into more districts is better. By the way, Republicans more than anybody else, love these majority-minority districts. Jerry said he didn't know anybody who's been a Section 2 plaintiff. I've been a Section 2 plaintiff a lot of times, not because I wanted to help Republicans. Once you create the majority-minority districts, the two adjacent districts are great Republican districts. So, to go back to Justice Breyer's analogy, the disease in 1965 was pneumonia, and it doesn't tell you whether or not the common cold, the second generation, still exists in these districts. It was incumbent upon Congress to find that there was some second generation problem that was not amenable to remediation under Section 2, which again, they didn't try and do either through updating the formula or through asking the question.
Is the second generation problem, is it limited just to vote dilution here in terms of redistricting?
Well, that's, as far as I can tell, that's what everybody's talking about, is vote dilution, right? They're talking about, you go from the ability to cast a ballot, which I don't think any serious person argues that minorities are being systematically excluded from casting a ballot. Then you get to the second question is, do you win elections? Right? Mm-hmm. Well, I'm a Republican in the district, and believe me, I'm never going to win an election. Mm-hmm. But nonetheless, the argument is if you can't elect your preferred candidate of choice and you're a minority, you've been denied some basic right. And that's why we create artificially these districts, predominantly or majority minority districts, where they can elect their candidates of choice. And the argument is that the retribution one that Jerry said. Whites got to a long time where they got to elect their candidates under a discriminatory system, and two wrongs make a right. So let's have minorities engage in the same sort of entitlements.
Well, and, you know, a lot of discussion of first generation, second generation voting discrimination assumes, or the implication is, that vote dilution is equivalent to racist registrars in Mississippi saying, I don't care if you have a PhD or whatever, you're not going to vote if you're black. And we've just come a very long way from that. There is a world of difference between these quote-unquote vote dilution discriminatory situations and what the Voting Rights Act was designed to combat. And by the way, in my 1987 book, published before most students were even born, I'm sure, most students here were even born, or for a lot of them were even born, in 1987 I said, hey, Republicans are laughing all the way to the political bank with these gerrymandered districts because they drain blacks from surrounding areas, and the surrounding areas which are bleached become fertile ground for Republican candidates. When I said that, everybody said, she's crazy.
Okay, so let us do this. Let us go to each person take a minute and a half just to kind of provide some closing thoughts. We're going to go in the order of Abby, Dara, Mike, and Jerry.
All right, my closing thought. Well, first place, I had a bet with Mike, and I've already lost it. And I'm delighted to lose it. I bet with him the last forum we were on, I bet with him that Section 5, and more importantly, really, Section 4, which determines the coverage, which is the coverage formula. We haven't talked about Section 4 here, really, except indirectly. I bet him that they would survive the Shelby County case, that they would be left standing at the end of the day. And having sat through the oral argument, I think I'm wrong, that Mike and I won that day, and I'm going to be very surprised if the Supreme Court does not come down making at least some of the arguments that we've been making, and the bottom line, with the bottom line being one that we are pleased with. What else do I want to say as a closing statement? I think I'm just going to leave it there, that I was very happy with the oral argument.
Okay. Dara?
Yeah, I'll follow up with my predictions as much as I can make one. After the arguments, after reading news reports, I kind of felt like I was in a different courtroom than most of these reports coming out, because I didn't feel as terrible about it as most did. Justice Sotomayor came right out of the bank, and she didn't just tip her hand, she laid her cards right out on the table. And it really seemed to be a main point for them that this is Alabama, this is Shelby County that's bringing this case. And I do think there is a very good chance that the act can be upheld 5-4.
Mike?
Well, I argued the Affordable Care Act last year, so I've stopped making predictions about how cases are going to come out based on the arguments. Look, the truth is that I thought it's clearly going to be 5-4, and I thought 5 of the justices were making essentially the points that I was making today, that it's really not realistic to use a formula from 1964 to determine, to separate out the real problem jurisdictions from the non-problem jurisdictions in 2006. And I frankly took great solace in the notion that, as Dara just mentioned, the liberal justices kept focusing on Alabama, and can't we keep at least Alabama in under the coverage, because you don't start looking for a partial victory if you think you've got a decent shot at a real victory. So I would think that given the fact that Section 2 so obviously deals effectively with whatever lingering problems are, given the fact that, as a unanimous court said just 3 years ago in Namundo, that there's more similarities than differences between the covered and non-covered jurisdictions, and given the fact that you can write a fairly narrow opinion, which doesn't say, look, we're not saying Section 5 is not something that Congress can do, we're just saying they've got to do their homework before they do it, and they can send it back and say, come up with a formula that's more geared to real problems in the 21st century instead of this residue from the Jim Crow South of the 1960s. I predict that if they send it back to Congress, Congress will be absolutely unable to come up with any kind of coverage formula that reenacts Section 5 in any jurisdiction.
Well, as they were not able to come up with another formula in 2006, and there was certainly a lot of discussion of that. By the way, for anybody who's interested, I have a long piece on the SCOTUS blog on the oral argument in Shelby County, in which I reversed myself in terms of my bet with Mike. But anyway.
Jerry?
Well, I'm not going to make a prediction about how the case will turn out. I would point out that I think a lot of journalists who write after listening to the Supreme Court arguments have a tendency to overly focus on some of the judges and their being far left or far right in some of their questions in an effort to predict. And so, you've heard a lot about in the aftermath of the argument about racial entitlements that Justice Scalia used, and there was so much focus about that, and then Chief Justice Roberts' misuse of the statistics involving Massachusetts and comparing that.
Not a misuse.
It was a misuse of statistics.
Look at a very good article on that on the
Facts are stubborn.
Secretary of State.
Yes, facts are stubborn things. Look at a very good article on that question on the Cato website.
Yeah, well,
it's excellent. Ilya Shapiros.
I'll listen to the Secretary of State of Massachusetts. But in any event, what I would say is the second generation of, is the Voting Rights Act still needed? That is ultimately the question that is going to be decided. And as I said earlier, if the Supreme Court wants to be a rogue court and go out and strike down a statute that it has previously upheld on at least 3 occasions, arguably 4, and has termed this, even in the City of Bernie line of cases, has termed the Voting Rights Act the ideal remedial legislation under the congruent proportionality analysis of Bernie. Language which is not in the Constitution, by the way, but appropriate legislation is, but we leave that for another day. We see all kinds of second-generation problems continuing today. We see voter ID laws being passed. We see early polling sites being closed in Florida that is blocked by Section 5. We see voting officials in some places intentionally creating long lines in the minority community because they see people those people have a tendency to vote a certain way. Going to Mike's point about the doctor and the disease, if you look at Congress as a doctor in 1965, Congress said, we have a real disease. The disease is voting discrimination, and we're going to try to put a cure to it. And we're going to impose this preclearance regime in order to cure it. And over time, some people got better. Some people got better, and they can bail out. But some people are still sick, like the state of Texas, and they still need Section 5 preclearance. And so today, Does the doctor say, well, there may be some people over there who are sick too, over in Los Angeles, and they're not subject to this same treatment of medication? Well, you don't stop treating the patient. You don't say, okay, only take half the penicillin because, we got some people over there who are sick too, and maybe we should be paying attention to them. Congress should be allowed to decide when it's time and when racial discrimination is over with respect to the right to vote, not 9 unelected justices on the Supreme Court.
Okay, well,
We're terrified of
and
any issue
we
involving race.
do need to wrap it up here.
And I want to thank Michelle Seeger. I want to thank all the students in the Political Law Society for organizing this great event. Our extended time, I know these panelists want to keep going here. They want even more time in terms of answering these questions from oral argument. A lot of insight that hopefully will make its way online to an inquisitive clerk on the court who will hopefully listen to them. And we will see you all at our next event here at GW. Thank you all so much for coming.
Thank you.
Thanks. Thank you very much. Yes, sir.
Thank you.